start with the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning. Next I have is the approval of today's agenda.
Make a motion to approve the agenda for today.
I'll second that.
It's been moved and seconded. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye. Motion carries. Now I have the approval of January 22nd, 2020 minutes.
I'd make a motion to approve the minutes as presented from January 22nd, 2020.
I'll second it.
It's been moved and seconded. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye. Motion carries. Now I have is the approval of claims for payment dated 1/29/2020.
Make a motion to approve the claims for January 29th, 2020.
Second that.
It's been moved and seconded. Any discussion? Hearing none, all in favor say aye.
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 Motion carries. I have no utility permit today. Secondary roads, anything?
Okay.
Next I have is the appointment to the Iowa River Trail for Hardin County Board. Or Hardin Board, excuse me.
I will make a motion to appoint Bob Johnson from Union to the Iowa River Trail Hardin Board.
I will second that.
It's been moved and seconded. Any discussion?
I do have a couple that are no longer on the board. However, I don't know that we want to remove their names from the board list because it wasn't on the agenda, but I don't know if we can do that under this same.
Can we do that next week?
Just put it on
Do
for
the
next week.
removal?
Okay.
Okay.
All right.
Any other discussion? Hearing none, all in favor say aye.
Aye.
Aye. Motion carries. Economic Development Advisory Council funding request.
I'm going to go ahead and ask that we table the Economic Development Advisory Council funding request until Angela's here to explain that.
I'll second it.
It's been moved and seconded to table. Is there any discussion? Hearing none, all in favor say aye.
Aye.
Motion carries. Next I have is Becky Shipper with questions on economic development. Becky, can you come up to the front here?
Actually, I'm not
Becky,
gonna
Becky,
keep-
can you please come up? Thank you.
I've emailed all the questions to each of you, so I'm not gonna do an interview during an open meeting. I just don't see the benefit of that for any of us. So if you could just take a few minutes and answer those questions and email them back. And
Okay.
then if I have any questions, I will call you individually. I think that's probably the easiest way to
Sure.
go about this.
Okay.
Okay.
All right.
And then we'll still
Sounds
meet
good.
Yes,
briefly here.
please.
Yep. Thank you, Becky.
Thank you. Now I have is an actuarial services agreement with Silverstone Group Incorporated.
I'd make a motion to approve the actuarial services agreement with Silverstone Group.
I'll second it.
It's been moved and seconded. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye. Motion carries. Now I have is clarification of county attorney of resolution on chapter 459, public hearings and written comments. Darrell, come on up.
Good morning. I just thought that I needed to come up here and maybe take another run at clarifying the resolution that was passed last week. And so I have some of my thoughts here written down so that I am as clear as I can be. Last week, the board had passed a resolution providing for public hearing and public written comments regarding construction applications under Chapter 459 of the Iowa Code. At the meeting, there were questions and concerns raised by members of the public regarding the policy. And at that time, I stated that the policy allows for both public comments at a public hearing and for the opportunity for citizens to submit written comments. And then subsequent to adopting that policy last week, I've fielded a few phone calls with additional questions about the scope and I guess any limitations that resolution may put on free speech, et cetera. So that's what I'm here to try to address this morning. What the what the law says about public hearings and public comment under Chapter 459 is set forth in the resolution. I don't know if that's, hope that's on your screen, maybe back one screen to the actual whereas page. In that third whereas section, even though it's not highlighted, it says the board shall provide for comment. Then there's two ways to do that, at a public hearing or in writing. It says the board may hold a public hearing, so public hearings aren't required under 459. Some counties, as I said last week, like Tama County, just receive written comments for or against an application. So there are two ways to make comment, public hearing and written comment. The law doesn't require public hearing comment. Now you can also call the supervisors and blow their phone up and say you're for it or against it. That's fine too. That's a way to express yourself. But there's no requirement that there be a public hearing. But we provide for that in this resolution. In the fourth paragraph of the resolution, it states, the board's recommendation may be based on the master matrix or may be based on comments under this section, regardless of the results of the master matrix. The words under this section specifically are referring to section 304 of chapter 459. So those are the things that, the comments that can be made to the board have to relate to chapter 459 if you're in support or opposition to an application. In the next paragraph, it says Iowa Code 459-304 sub 5 sub B provides that if the board's disapproval of an application is based on something other than the matrix, so it's acknowledging that there are things the board can use to make a recommendation for or against a matrix or an application other than the matrix. It says the Iowa DNR will consider any timely comments that relate to requirements of Iowa Code Chapter 459. So again, the scope of what can actually serve as the basis for a denial or recommendation of an application have to be found in Chapter 459. So on the next screen, the policy statement is just another expression of what those legal principles are. It states the people have the right to submit comment to the board under procedures adopted by the board. Now that's even, not only is that stated in chapter 459, but it's also stated in chapter 21 sub 7 of the Iowa Code. It says regarding public meetings, nothing in this chapter shall prevent a governmental body from making and enforcing reasonable rules for the conduct of its meetings to assure those meetings are orderly and free from interference or interruption by spectators. So in the policy statement, we captured the essence of what's in chapter 459 and chapter 21 by saying that people have the right to submit comments, but it says the following procedures for public comment and public hearing are intended to afford the public an opportunity to bring to the attention of the board in an orderly and civil manner. Therefore, we don't want you to violate chapter 21. We don't want you to violate any other code sections. So we just want these to be civil expressions of your opinions, your objections, your support of an application. So if we go then to the next section, the procedures for a public hearing, and this is where you can come to a meeting and you can express your opinion about an application. It doesn't matter if it's under chapter 459 or not. You can say whatever you want at this public hearing, but it needs to be in a civil, orderly manner. And the procedure says that the manner of receiving the comment at a public meeting shall be at the discretion of the board chair. So if you're kind of going far afield, as in any meeting, the chair can rein you in, maybe try to help you bring it home so that you aren't just going on and on and on, monopolizing the time that you know is there for the other folks that are in attendance. You know, that you don't want to waste their time either. So there's some discretion in the chair to kind of keep it pertinent, keep it germane, keep it moving along. It says failure to comply with these procedures will result in sanctions. I've had some expression of concern about what kind of sanctions are you talking about. Well, certainly you could be asked to wrap it up. You could be asked to sit down. You could be asked, if you're disruptive, you could be asked to leave. But chapter 723.4, subparagraph 4 of the Iowa Code, defining disorderly conduct. It's actually a criminal act. It says, a person commits a simple misdemeanor when the person does any of the following. Without lawful authority or color of authority, the person disturbs any lawful assembly or meeting of people or persons by conduct intended to disrupt the meeting or assembly. So if you don't act in a civil, orderly manner, the law says you can be charged with a crime. So we're just, one of the things about our system of government is self-governance. Now that means kind of two things. One, in the macro sense, it means the people get to participate in what laws they have to live by, rather than a king or an oligarch or something like that. The people get to participate in the process through our representative government. That's macro self-governance. But as important, and maybe more importantly, is micro self-government. Govern yourself civilly, respectfully. That way we don't need a bunch of laws. If men were angels, we wouldn't need government. You need to practice self-governance. Conduct yourself respectfully in a public place. So if you don't, there are sanctions. Now there was a lot of concern over the next section about the public comment, and maybe it should have said procedures for written comment, something to make it a little more explicit. But as I said last week, what I was trying to do was, not only just make another statement of what the law is, because you have to make timely comments. That's what Chapter 459 says. So timely, under our procedure, is send it to us before the public hearing or bring it to the public hearing. Right? Beyond that, once the public hearing is closed, it's no longer timely. It will not be part of the file that goes to the DNR with a recommendation. So again, it's just another way to restate the law, but give you guidance. What do I need to do to make my written comment effective? Get it in timely. Number two, we'd ask that you clearly express a comment, whether your comment is for or against. I've seen people, express their opinion, but it's hard to say whether they're for or against something, because if you say I'm for clean water, well, so somebody that's for the application could be for clean water, because the matrix is designed to assure that in some way. So don't just say I'm for clean water. I'm against this because I'm for clean water. I mean, at least then we know you're on what side of the fence you're on in your comment. Be clear, just up front, simple. And then the third, we'd like one person, one written comment per person. It avoids sort of the drip, 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 the Chinese water torture. If you keep sending a thought in writing, then another thought in writing, and then another thought in writing, you collect yourself. We're asking you to try to collect all your thoughts so that they're kind of all contained, so that we know who these comments are coming from, for one thing. We have the name, the address. But it's easier to manage the public comments if your one comment per person comes in all in one document, rather than the drip, drip, drip. And then number 4, again, it says all written comments shall clearly and expressly identify the statutory provisions under the code 459 that forms the basis for or against the application. So if you say, I just don't like the smell, well, you probably won't be able to find something in 459 that deals with that. So you can't say under 459 you need to deny this because of the smell. That wouldn't work. You can still say you don't like the smell, but you wouldn't be able to link it to anything under 459. So we're just asking you to please do that homework when you submit your comments. Link it to something if you can, because that's what the Board of Supervisors is going to have to do if they make a recommendation, and especially if the recommendation is to deny, they have to link that to something under 459. So help them do that. You can say whatever you want in your written comment, but help them connect those dots if those dots are there. That's all we're saying. So it seems like that last sentence of section 4 that's in green on the screen there, the lawful grounds that can be considered by the Iowa DNR in denying an application are set forth in Attachment A. And Attachment A is just a statement of what the law is. And if to make this clear, if that last sentence of Section 4 and Attachment A just need to be stricken, that's fine. But there's no legal need to do it, but if it makes it more clear to the public, and we don't want to discourage public comment, so if something about that sentence that links to attachment A appears to be discouraging the public from participating in our collective self-governance, then maybe we should tinker with this a little bit and modify it, but it was always intended to help you express yourself as effectively as possible. It's not intended to stifle or squelch anybody's opinions about an application. Another reason for the need for this link under Chapter 459, I can go kind of circle back to a letter that I had prepared a month or more ago regarding a citizen's question about whether the board can just deny an application. No ground really at all, just deny it. They just feel that we've had enough of these and we're just going to deny it. And the simple answer was yes, but the DNR is going to look and see if the matrix was passed and it's going to approve it. So the question is, why would you do that? Why would you say no if there's no legal basis to do it? And I used the word frivolous in that letter. Now, frivolous has a legal meaning. I'm not saying that clean air is unimportant. I like clean air. I do not consider that to be something frivolous, or water, or the noise, or the traffic, or the wear and tear on the roads. Those aren't frivolous things, but they aren't found in Chapter 459. And I said, if you go down that road and you want to then appeal this, you're going to have to find that legal reason under Chapter 459. And if you don't have one, you're going to face sanctions. There's that dirty word again, but there are going to be sanctions, and it's going to be paid by me, the county, and my client, which is the county and the supervisors. Iowa Rules of Civil Procedure talk about what is frivolous. Rule 1.413 describes it this way. It says, counsel's signature to every motion, pleading, or other paper shall be deemed a certificate that counsel has read the motion, pleading, or other paper to the best of counsel's knowledge, information, and belief formed after reasonable inquiry is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law, and that it is not interposed for any improper purpose, such as to harass or cause an unnecessary delay or needless increase in the cost of litigation. So if we deny something without a legal basis, somebody that's injured by our action is going to claim that we did it just to throw up a roadblock, just to make it more difficult. It says, if a motion, pleading, or other paper is signed in violation of this rule, the court, upon motion, because the other side that doesn't like what you did, or the court on its own initiative, it says, shall impose upon the person who signed it, which would be me if I'm doing your appeal, because DNR reversed your denial, you want that appeal, it'll be me or some other lawyer, but if they sign that, it says, shall impose upon the person who signed it, a represented party, which would be the county, or both, and other party or parties, the amount of an appropriate sanction which may include, in order to pay the other party or parties the amount of the reasonable expenses incurred because of the filing of the motion, pleading, or other paper, including a reasonable attorney fee. So if we cause them delay and they've lost some business, their business plan has now been scuttled and delayed, etc., that's on us. And their attorney fees, that's on us if we deny something outside the law. The next section of under 1.413 actually uses the word frivolous, but everybody knows, if it's gone to law school, knows that what I just read to you is frivolous. That's the definition of frivolous. The federal rules have the same thing. But here it says, if a party commencing an action has in the preceding 5-year period unsuccessfully prosecuted 3 or more actions, the court may, if it deems the actions to have been frivolous. So if what you had done before was frivolous and you keep doing it, the court can stay the proceedings until the party, county, furnishes an undertaking secured by cash or approved securities to pay all the costs resulting in to the opposing parties in the action, including reasonable attorney fees. So there's those darn reasonable attorney fees again, and we got to pony up. So I've advised the board to not deny these applications if there's not a ground under 459. Now, it doesn't stop you from raising grounds that aren't under 459, but they're going to fall on deaf ears, all right? Because there's no legal basis to do it. So I hope that that helps to clarify the resolution that was passed last week. And if the board is so inclined to tinker with this, I can make some revisions by adding the word written in the second procedure that talks about comment. Could call it written comment, and we could strike the last sentence from paragraph 4 and just get rid of attachment A and not try to be as helpful as we were trying to be. So that's.
Thank you.
Thank you,
Yep,
Darrell.
thank you,
There's
Darrell.
somebody's got a comment or question, maybe I can try to field it. So.
Julie, would,
I should go up there.
yes,
Okay.
please.
I will. I do want to ask Mr. Meyer if a denial on the grounds of just standing up for good quality of life in a county, would a denial by supervisors then require an appeal? Does it require an appeal?
No.
Okay, thank you. So just if they chose to deny it, that doesn't mean that they're going to ask for an appeal, which would cost money, which, so no, it doesn't necessarily, it's not gonna cost the county money if they choose to deny it. No, sometimes you just have to deny things because it's the right thing to do. And you know that the practice of law is adversarial. Your opinion is an opinion. Other attorneys may have different opinions. And sometimes meeting in the court of law to work those things out is what makes change. So that's a thing too. And could you please point out to me times in public comments over factory farms, please point out to me instances of civil and disorderly, or uncivil and disorderly conduct that you would need to bring this up now. I do not believe that they have been disorderly or uncivil. We're given a certain amount of time, we stick to it, although maybe the other people on the other side do not, but we try to do that and we try to be civil, not call out personal stuff. So I'm waiting for examples of disorderly conduct at public hearings. And I don't know, do people normally submit more than one written comment? Do you get a lot of written comments? Sometimes you don't need to go to places that really aren't, I'm like, really? People are doing that? Okay, good. Whatever. This just felt like in a resolution that, yes, I could watch out, you may not want to do this. And I don't know, loss of enjoyment of life, is that, I guess, whatever. That's not a grounds for people to stand up and speak out on. Noise, traffic, dust, particulate matter, and dust and odor. There's stuff in there. We may not be scientists as citizens, but scientists have pointed out threats to health in odor and dust through particulate matter. But anyway, I just didn't appreciate this, and it feels like just trying to discourage the public from from commenting on these important things that affect their enjoyment of life, their health, and their safety. Thank you.
Are there any other questions? Hearing none, and afterwards, does anybody want to have this changed? Would you like him to?
I'd like to confer with Attorney Meyer
Okay.
individually.
Okay. So from there, I will go to change of status as community services.
I'd make a motion to approve the imminent resignation retirement of Carol Haywood, who is administrative assistant in the Community Services Department. It'll be effective on April 3rd, 2020. She's been here since August of 1999, and she put a really nice resignation letter in. And this will just give Lynn some time and the attention needs to fill the position going forward.
Okay, I'll second it.
It's been moved and seconded. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye. Motion carries. Next I have is change of status on property management.
I'll make a motion to approve the employee change of status for Jared Manater. It's a resignation from full-time employment, effective January 21st, 2020.
I'll second that.
It's been moved and seconded. Any discussion? Hearing none, all in favor say aye.
Aye.
Motion carries. Now I have is change of statuses at the sheriff's office.
The first one I've got is the demotion of Jamie Koltoff. This is Koltoff is moving from full-time to part-time at a pay rate of $15 an hour. Last day of full-time will be January 31st, 2020. All wages, comp time, vacation time will be paid out with the next paycheck.
I will second it.
It's been moved and seconded. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye. Motion carries.
The last one I have is the promotion of Heather Jolas, who's a communications dispatcher. Heather is moving from part-time to full-time on February 1st, 2020, with a pay increase to $16.76 an hour.
I'll second it.
It's been moved and seconded. Any discussion?
The effective date on that is February 1st.
Any other discussion? Hearing no more discussion, all in favor say aye.
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 Motion carries. Public comments. Hearing no public comments. Any other business? I could ask for adjournment or recess.
Go ahead and make a motion to adjourn.
I'll second it.
It's been moved and seconded. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye. Motion carries. We're adjourned.